Our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, "Oh, I'm just going to JV it." Like, it's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today. So thank you so much.
Well, then that end buyer could come back and say, "Well, I didn't fully understand that it was subject to."
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Good morning, everybody. Welcome to the show. We're talking about how to avoid estate taxation. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like our channel. You can find us on Facebook, YouTube, and X, formerly known as Twitter. At all of those, you can find us at the handle @InRem Podcast. That's @InRem Podcast. Also, on Spotify, Apple, or the other major podcast platforms, you can download an audio version of the podcast. Probably the easiest way to listen to the show. You can do it while you're doing chores at home. Go ahead, go there, Apple Podcast, download it, subscribe, leave us a review. It helps us out a ton. We'd really appreciate it. With that, we're going to get started with Sean, who has our legal update.
Thank you, Andy. So the legal update today is basically reminding our listeners who generally are real estate investors of the importance of consulting with an attorney, not only an attorney, but a competent attorney in the state in which you are buying or selling real estate. And the reason why that is so important is a lot of times states have their own set of laws that govern real estate transactions, in particular residential real estate transactions, creative finance transactions, transactions involving distressed real estate. So a few examples. We have Scott Horn and Alan Seschker on this show regularly. They're out of Texas. Well, in Texas, you're limited on your ability to do a land contract or a contract for deed, a lease with an option to purchase. There are limitations on that. You can't just go and do those transactions willy-nilly. There are certain circumstances in which you can, but other circumstances in which you can't. And you have to know that. Otherwise, you're going to end up getting yourself into hot water. Another example is in Colorado. Colorado has basically a foreclosure rescue law, which most states have, but theirs takes it a step further than just dealing with foreclosure consultants. Theirs goes into foreclosure purchasers. And a foreclosure purchaser is basically anybody who is buying a property that is where the loan is in default. And default is defined as over 30 days past due. So it doesn't have to be in foreclosure. It actually has to be in default. And in that case, if you're going to buy that property, you still can, but there are a number of disclosures and a right of rescission that you have to provide the seller. And it has to be very detailed. It can't just be like, oh, you have 3 days to rescind. No, there's statutory language that has to be in that contract. And if it's not there, then the seller generally can rescind. And there's other, civil penalties that you face. In Wisconsin, where I'm also licensed in addition to Arizona, we have a foreclosure reconveyance statute, which basically is somewhat similar to Colorado, but it applies if somebody's buying a property that's in foreclosure with the agreement to basically lease back the property or to provide an option to purchase the property back to the seller. So it's a foreclosure reconveyance scenario. In that case, you have to also have very detailed statutory disclosures in your documents. So, just because you're successfully doing transactions in one state Doesn't mean all of a sudden that you can cross state lines and go and do those identical and same transactions in other states. You have to know what the local state laws are with respect to residential real estate transactions, dealing with distressed property, creative finance, and make sure that you're not doing anything contrary to those statutes, because there could be significant penalties and consequences for doing that. So just a reminder, this is my legal update. Consult with a competent real estate attorney in every state in which you are investing in or buying or selling residential real estate.
All right. Thank you, Sean, for the legal update. Let's talk about a few announcements we have here at the show. Every Tuesday, 2 p.m. Arizona time, we have the Creative Finance Collective. What is the Collective? It is a live show of lawyers in the space of creative finance from a variety of different states that get together to talk about all things creative financing. We talk about the laws with respect to the states that we're practicing in, problems, victories that we've seen with regard to clients, what works, what doesn't work. And we talk about the matter in a way to basically make our practices better and to try to bring value to you. But the biggest thing that we do is we all make ourselves available to you, the listener, to answer any questions that you have about creative financing. So if you've thought about this as an opportunity from the investment perspective, you've heard about this. Is this real? Is this legal? What are the risks? What are the rewards? We slice and dice it from the legal perspective. So if you have questions, this is your opportunity. Free of capture here. We're not charging anything. You have an hour of our time to discuss all things creative finance. If you're not there, you miss the opportunity. You'll be able to watch it after the fact, but the real value is being there to ask questions. So we're on as long as we get questions, and once we stop getting questions, we move on because we've got a group of lawyers that are busy. So be on there. We enjoy the questions and we like to work through it. 2 p.m. Arizona time. You can find it on YouTube, Facebook, or X. You can go to all those. It's live, and we're taking questions throughout the entire episode. Also today, as I mentioned, we're talking about estate taxation and avoiding estate taxation. If you have questions today about that topic, make sure to post them in the chat. We're going to get to questions in the final 15 minutes of the episode if we have them, but it's a good discussion, and it's information you're not going to have readily available to you unless you go pay for a consult with a high-end estate planning attorney. So make sure to ask those questions if you have them. With that, we're going to get into our topic today. And as I just mentioned, the topic is avoiding estate taxation. With us to discuss that topic is attorney Logan Woodruff. Logan is an attorney with the Woodruff Law Firm, PLC. Logan, thanks so much for joining us.
Happy to be here. Thanks for having me.
So we're talking about estate taxation, but before we get into that, Logan, tell us about you, your law firm, and how you got into doing what you do.
Yeah, so I've been doing estate planning now about 10 years. Prior to law school, I was actually in construction, did that for a while. Loved seeing things go up and building. Didn't love necessarily working out of a trailer, so went to law school. My wife supported me there and been doing estate planning and estate tax planning ever since. So yeah, I worked for a number of small firms in Arizona, small, medium-sized firms. And last year, I started my own firm. So just me right now, but love working with clients all across the country to help them with their estate planning and estate tax planning. I'm licensed in Arizona, Utah, Texas, and Oklahoma, but on the estate tax planning side, I do that nationwide. So.
Now, Logan, you mentioned you were in construction before law school and doing all that. Were you in construction in kind of the heart of the Great Recession, or had you just missed that?
Yeah, so my undergraduate degree was construction management, and so I went to work in 2008 in construction, and then with the downturn in 2010, I said, hey, maybe I should rethink my life choices, and went to law school. So yeah, it's been good ever since.
Yeah, Sean and I. Boy, at the time, I don't know if you'd agree with this, Sean, but I guess that we used to work at a firm. I guess you might call it kind of a construction litigation law firm. So Sean and I both have done a good bit of construction litigation, but we were practicing that practice area in the heart of the Great Recession. I think we still have PTSD from that time.
Yeah.
Yeah,
So-
all of our clients were contractors and developers. And so, unfortunately, we had a lot of clients, but a lot of clients that couldn't pay us. So it was a rough few years.
Yeah.
And we tried to do the best we could, but we actually ended up doing a lot of the like consulting on short sales and foreclosures and stuff like that. But it definitely was trying times out there in the construction and development world.
Yeah. So, Logan, we appreciate you being here. We've wanted to talk about this topic for some time, and we're going to get into the details, and we'll even get into the weeds, but we like to start from 30,000 feet on these things. Define terms, help the listener understand what we're talking about, because everybody has a preconceived notion about what they think something means, but we want to start pretty broadly with this. But help us out here. Why don't we start with, what is estate tax?
Yeah. So it's what most people think of as the death tax, right? When you die, all of your net worth is added up. And if it's over a certain threshold, well, then the government wants another piece of the pie, if you will. And so depending on how you own assets or what type of control, that can either be included as part of your taxable estate or not. So currently right now, in terms of a federal threshold, the federal threshold is 13.61 million, meaning if your net worth is less than that, you can pass everything on to your children and pay no estate taxes. But for anything above that, there's some tiers, but essentially $1 million over that, you're paying about 40% in terms of estate taxes on net worth above and beyond 13.6 million. So for a married couple, that's 27.22 million in terms of net worth. So that's an individual threshold that you have to meet.
So let me just clarify, because I think there's a lot of confusion on this. A lot of people think that if I'm over the threshold, that my entire estate is taxed, and that's not the case, right? You can pass basically 13.6 million roughly tax-free, but then it's the amount above that's taxed. Is that correct?
Correct. Exactly right. So yes, that first 13.6, everything goes to the kids, to your beneficiaries, no estate taxes, but everything above that, then yeah, you're looking at roughly 40% above that.
Now, do states, you mentioned the federal, do states have their own estate tax?
Some states do. Arizona does not. There's about 12 other states that have different taxes, thresholds, anywhere from $1.5 million up to 13.6 as well. So in addition to the federal percentage that you'd be paying some to the state as well. So it just depends on where you live and where you claim your residence. So I've got a number of clients who, live in those jurisdictions. And when we have that conversation, they say, okay, that's a good reason for me to move. So we're going to find another place to go. So we're going to save the kids money when we pass away.
So give us an idea from the listener's perspective about, to quantify this. In a state, well, all states are dealing with the federal estate tax. That's a given.
Correct.
So assuming you're in a state, and I know you don't practice in all these states, so you may not know this, so that's fine. But assuming you're living in a state that is subject to both federal estate taxation and state estate taxation, what kind of percentage of their estate could they be looking at being taxed?
Yeah, so it's another, usually anywhere from 5 to 10%. Like you said, it depends on the state. In the 12 states I know of: Connecticut, Hawaii, Illinois, Maine, Maryland, Massachusetts, Minnesota, New York, Oregon, Rhode Island, Vermont, and Washington, just to name a few. But yeah, they can range in terms of the percentages there.
Okay. And you mentioned Arizona does not have a state estate tax.
Correct.
So is there any exemption to the state tax? I've heard of an estate tax exemption. Is there something, is there an exemption, and what is it?
So that's that 13.6 million number that I mentioned, meaning you can have that amount of assets exempted from the estate tax, but anything above and beyond that. Now, in terms of the way to think about it as well is, and this is more from the IRS's perspective, with them in mind, they're thinking of the, multimillionaire, billionaire type, right? Of, all right, we want to tax this person's net worth at 40%. And so they're worried that the billionaire during their lifetime will gift away assets so that when they die, there are no assets left to tax. So the thought is, at least from the IRS perspective, is that's where the gift tax comes into play. So you could keep everything until you die and pay 40% above that threshold. Or if you gift away assets, the IRS will allow you to gift away, guess what? Also 13.6 million this year during your lifetime, gift tax free. But then anything above that threshold, you would pay a gift tax on if you're wanting to gift that during your lifetime. So the thought there is, if I gift away assets, I no longer control it. It's not part of my taxable estate, and therefore, the 40% tax wouldn't apply. And so that's one of the, strategies that some people use during their lifetime is, hey, I just want to go ahead and start gifting money away. And you can do that annually. This year, it's $18,000 per person. You can gift away, and that doesn't cut into that 13.6 million. So you've got, 20 friends. You could gift each of them $18,000, whether it be kids, grandkids, or whatever, and you're not cutting into that threshold. And when you do that, now those assets are not part of your taxable estate. But if you're gifting, let's say, $100,000 to somebody, anything above that 18,000 would be subject to the gift tax and would also cut into your overall lifetime exemption amount of the 13.6 million.
So let me ask. So now I'm struggling here to figure this out. So if I want to just give 18,000 away per year, I can do that. But then at some point, I still have 13 million to give away. And then is it a one-time gift, or can I give like a person 100 grand and say, oh, this eats into my 13 million. And then the next year give someone else 100 grand and declare it so that, and then is there a gift tax that's paid on that? How does that operate?
Great question. So what that is you have to file a gift tax return each year. So let's say in my scenario, I've got 5 kids and I want to reduce my exemption amount. And so I say, okay, I want to give each of my kids $1 million this year so that it's not part of my taxable estate. Well, that year I have to file what's called a gift tax return saying, hey, IRS, I gave away this $5 million. And so instead of 13.6 million left at when I die, I now have 8.6 million left when I die. So when that happens each year, yes, I gave away $1 million to each of my kids. There's no tax that's paid on that gift at that point in time. But now when I die, I have less of a threshold of assets that I can pass on estate tax free. So the gift tax follows the estate tax because the IRS doesn't want the billionaire going and giving away all their money and then having nothing left over for them to tax at the end of the day.
Okay, so you don't have 13 million during your lifetime and 13 million upon your death. If you give gifts above the 18,000 per year per person exemption, you can file a gift tax return. Nobody has to pay tax on that. But when you die, you've now lowered the amount of your exemption.
Exactly right.
Is that?
Yep.
Now, I heard something one time about like a one-time, like lifetime, like exemption, like you can just give it all away, tax-free or something like that. How does that work?
Well,
or was that even a thing?
I guess it depends on who you're giving it to, right? So,
okay.
In the rules of the IRS and society, we like charities. And so, yeah, if you want to give all your money away to charity, like some of the billionaires out there, Gates and whatnot, yeah, you can give all of your net worth away and there's no taxes associated with that. But to say I want to give it all to my kids right now and No, that's not the case. You can do some
Okay.
things with 529 plans in terms of supercharging
Okay.
those. You can say, hey, I want
Right.
to give 5 years worth of that $18,000 this year, and then spread it out over 5 years in terms of
Mm.
each of the years you're filing the gift tax return. But no, to say I want to give it all away to a friend or a family member, estate tax free or gift tax free. No, that's not the case.
So, Logan, talk to us about the nature of the laws, or maybe a better way to put this is the changing nature of the laws. And specifically, I'm talking about federal law right now. And I'll give you a little story. I remember in the early 2000s, my grandfather spent a good bit of time doing significant estate planning.
Yeah.
And that was, I guess, during like the George W. Bush administration. And they passed a big estate tax law that changes, back then the concern was, if we don't change this, farmers have to sell the family farm, right? Just to pay the tax, which
Yep.
was maybe 600,000 or something at the time.
Mhm.
And they changed it. And I think it was set to phase out completely in the year 2010,
And it did.
but it was supposed to sunset, right? It was supposed to end. And uh, funny side story, my grandfather, he ended up passing away in 2010, making none of it necessary because there was no estate tax in that one year. But there was a sunset clause, and things changed. How is the current state of affairs set up? Are our current exemptions set to expire? What does that even look like?
Yeah, so you're exactly right on the history there. 2010, as you mentioned, it was also the year that George Steinbrenner, the owner of the Yankees, died. So he passed the
Mm.
Yankees on to his family estate tax free. Maybe another reason to hate the Yankees, but um, in 2011, they changed the threshold. That was during Obama, because you're exactly right. There's a lot of Midwestern farmers who didn't want to sell the family farm, so they increased that threshold to 5 million. And when they put that in, there was a 5 million plus inflation. So each year that threshold would go up based on inflation. Well, then in 2017, with the Tax Cuts and Jobs Act, they retroactively doubled that from 5 to 10 million with the increased inflation. Okay. And so that's where we've gotten the 13.6, is that it is essentially increased. But in 2017, when they passed that, they didn't have enough votes to make that doubling permanent. So yes, there's going to be a sunset to that 13.6 million in 2026. And it's going to revert back to the 5 million plus inflation. So essentially, it's going to cut in half. So what I tell clients is probably going to come back down to around the $7 million mark in 2026. And the way that works is you have to use it or lose it before 2026. Meaning, let's say I'm worth 13.6 million, right? And I say, hey, I want to use up this exemption amount before it goes away. So I'm going to gift away, let's call it $6 million right now to use up that exemption amount. And then in 2026, and this is also if Congress doesn't act, right? If Congress wants to change the law, increase it, keep that permanent, reduce it, they can do that whenever they want. But let's say Congress doesn't act. And so in 2026, that threshold gets cut in half. Well, what I've gifted away is not part of the exemption that went away. It's actually what I have left over. Meaning, to truly use all of that 13.6 million, you'd have to gift it all away now before the threshold change. Because if not, if you're only gifting away that 6 million in 2026, you're only going to have $1 million left over because you already gifted away 6 million. So it's either a use all of it right now or you lose it type of thing.
Wow, interesting. So obviously, we're talking about numbers that for a lot of listeners is the moon, right? 20, even 5 million, the moon for the vast majority of people.
It's a quality problem, right? I wish
y-
all of our
y-
clients had that quality problem, right?
Yeah, right. And it'd be great to be in that situation. But, I think one thing that I've learned in the practice of law, even doing the show and talking with real estate investors or any type of investors, your station is in life is not always going to be what it is. And things can look very different over the course of 5, 10, 15, 20 years, significantly different. And, so one of the questions is, how do you plan for this? As somebody who you know, maybe has aspirations to reach that level. How do you start the estate planning process with these kind of possibilities in mind? One, how do you like to document that? And would the traditional estate plan for the average person be enough to protect them against that? Or is this really just kind of an evolving process they need to be prepared for?
Yeah, that's a great question. So to answer that question about the standard estate plan, I think what you're referring to is a revocable living trust. That's what
Yes.
a lot of people understand they need to have in place. A revocable living trust addresses incapacity issues, probate issues, allows you to transfer assets to your children without the need of going through probate and a complicated court process, all of that. I would say 99% of that standard estate planning does not protect you from estate tax issues if you have them. So, yes, I'm a big fan of having those in place, but you've got to do additional planning if you really want to avoid those taxes down the road. So how do you go about doing that? Well, I'm not a one size fits all type of attorney. I have a lot of options for clients in terms of exactly what you said. Maybe they're a couple million now or 5 million or so, and they know they want to grow their net worth over the next 10, 20, 30 years to, double, triple, quadruple that. Yes, there's planning that you can do now to be able to put yourself in a position where you don't have to deal with those issues, or I should say your kids don't have to deal with those estate tax issues. So what does that look like? Well, there's a number of different options there for people on the lower end if they're really worried about estate taxes. And here's the concept behind that. When you own and control your assets, the IRS says if you have the right amount of control of those assets and you're getting the benefit from them, we're going to include them in your taxable estate. So what people will do is they will gift assets outside of their taxable estate so that those assets can grow. But now when you die, there's no estate taxes that have to be paid. So people will do that with irrevocable trusts. You may have heard of an ILIT, and it's a life insurance trust, an irrevocable life insurance trust. And what that is you essentially gift the life insurance premiums to an irrevocable trust, right? The gift of those premiums is now outside of your taxable estate. You're not in control of that trust. The trust goes out and buys the life insurance policy on your life, and your kids are named as the beneficiaries of that life insurance policy. So each year you're now gifting those premiums to the life insurance trust, and let's call it a $10 million policy that's out there. Well, that policy and the proceeds are no longer part of your taxable estate. So that when you pass away, you now have an extra $10 million that you can use a part of that to pay the estate taxes that might apply to all the rest of your assets. So, if we're talking, I guess to use an easy number, right? Let's say your net worth was 37 million between you and your spouse. That means you can shelter approximately 27 million from estate taxes with your exemption amount, but then you have $10 million left over when you pass away. Of that 10 million, you're looking at a 40% estate tax, so $4 million. Well, if you had that life insurance trust that purchased the life insurance policy, you now have, let's call it either 10 million or 4 million, whatever. You now have $4 million worth of cash there to pay that estate tax, and now all the kids get 37 million instead of 37 minus the 4 type of thing. So for somebody who might be on the cusp, an ILIT might be a great option. It's not as expensive as other options out there, but it gives you more liquidity because you're gifting out assets outside of your taxable estate. And now you have more liquidity to pay those taxes down the road. There are definite downsides to that. You can't do that type of gifting with all of your assets. Most clients don't want to gift away real estate or brokerage accounts because they want to use them in retirement or, going on vacation and stuff like that, whether it be an ILET or other types of irrevocable trusts. And that's really what you're dealing with when you're talking about estate tax planning. Standard planning deals with revocable trust. I control it, I fund it, I can change it anytime I want. Because of that control, it's part of my taxable estate. When we're talking about irrevocable trusts, it would be, okay, I'm going to create this irrevocable trust. I'm going to gift assets into it. I no longer control it. I'm going to name somebody that I trust, whether it be another family member or business partner, somebody to be the trustee. I don't control how it's invested. I don't get the beneficial use and enjoyment of those assets. Yes, my kids are the beneficiaries, but that, let's call it 10 million. If you gifted away 10 million, I can't use that for vacations and groceries and standard living. So yes, you're moving assets outside of your taxable estate, but the downside is you don't get to control it. It is avoiding estate taxes, but there's ups and downs, a downside to everything when you're talking about those types of issues.
I read somewhere about charitable trusts. And when I read about it, I don't remember, it's been years ago now. I was like, oh, that's really interesting, because it seemed to allow you to still have some control, but at the same time, shelter your assets for tax purposes. Talk to us about charitable trusts. What are those? When would somebody want to use those?
Yeah. So when I talk to clients about that, what I tell them is, hey, you really have to have charitable intent. If you're wanting to do a charitable remainder trust, you really need to be benefiting a charity long term. Without that true charitable intent, a lot of it doesn't really pencil out. So here's the thought. You create this charitable remainder trust and you gift assets in there. In exchange, you get either an annuity payment or a stream of payments, depending on the structure of the trust, over the rest of your lifetime, okay, in exchange for that. And there's some tax consequences there. But the benefit of doing that is, let's say you've got very low basis property. You bought, a $10 million property 10 years ago for $1 million, right? And now it's worth 10 million. Well, if you gift that property into the charitable remainder trust and then it gets sold, well, now you don't have to pay the long-term capital gains on it because it's a charity. The charitable remainder trust sold the property, and so the long-term capital gains don't apply. Now, that charitable remainder trust is going to pay you an income stream over your lifetime usually. But at the end of the day, when you pass away, whatever's left over or remaining in the trust would go to that charity. So it depends on the ultimate amount that's going to be left to the charity in year 20 or whatever it turns out to be. That number is what you get in terms of a charitable deduction when you donate it. So you don't get a full $10 million deduction on your income taxes for donating it this year, but you might get $1 million deduction, or it really depends on how it's structured and the interest payments and all that. But let's just call it $1 million. You get $1 million deduction this year, plus an income stream over your lifetime, so that when the ultimate amount is left to the charity, that's where the deduction comes in. So yes, you can avoid capital gains taxes in that type of scenario, and you can ultimately be donating to charity if you're already doing that, whether it's through your church or something else. It might make a lot of sense to you, but yeah, there's a lot of moving pieces there, but it is a definite option for those who are charitably inclined.
Logan, break down for us when a client or a family's gone through basic estate planning, about when they need to really start thinking about making the transition to, I guess, what I would call just a higher end estate planning. And it's hard to, given our discussion here, it's hard to really put a number on it, because you could, let's say, be at a $5 million net worth. Conceivably, you would probably be right in thinking, well, under the current state of the law, I'm nowhere close. I'm nowhere close right now. I'm not even halfway there.
Right.
But with the change of a law in a year and a half, you're right on it, right? So things can change very quickly, whether your assets go up or the laws change. how should, the person who's kind of done the basic estate planning, maybe they've started early and, they anticipate trying to be in these categories. When do they really need to start thinking about planning for that, from your perspective?
Yeah. So I tell clients, you really need to be worried about it if you think your net worth is ever going to get close to that threshold, the 7 million per person or the 14 million per married couple. And I'm thinking of it in terms of the 2026, cliff there, right? Of that exemption amount being cut in half. I think it also really depends on the client's goals over time. So you're exactly right. If clients are in their 60s and they're worth $10 million now and they're going to sail off into the sunset and they're going to live on the interest or their, rental investments type of thing. Yeah, it may not be a big issue with real estate these days. I would say that may be a good reason to do some of that type of advanced planning, because with value of real estate going up so much over the last couple of years, that could definitely continue. Yes, there's no one set threshold of, hey, once you reach this dollar amount of net worth, you need to do estate tax planning. It's more along the lines of, what are your goals, right? So for instance, I have a client right now who's, my age, and he, built a business and he's going to be worth this year, 20 to 30 million. And he wants to grow his net worth over the next 20, 34 years to be double or triple that, right? So for him, it makes sense to do the planning now while we have enough exemption amount to whether it be gift away assets or do some other types of planning that I can talk about today, where you can set yourself up into a certain type of position where all of that growth can grow outside of your taxable estate, right? So if you have in mind of growing your real estate portfolio, your investments over the next 10, 20 years, and you thinking that they're going to be doubling or more, yeah, it's a much better idea to plan now with the estate tax planning, because it's a lot easier to do it up front as opposed to on the back end. And so yeah, it really depends on your goals and what you're looking at over your lifetime.
So you mentioned for a married couple, you can basically double the estate tax exemption. So, being in real estate, I look at like capital gains where husband and wife sell the house and they can double their capital gains exemption. But when it comes to estates and passing away, like, it's rare that husband and wife die simultaneously, right? So there's more to it than just simply being like, well, we were married, and so we get an automatic like doubling of this, right? Talk to us about what that really looks like and what kind of planning even has to be, has to go into doubling that exemption for a married couple.
Yeah, you're exactly right there, Sean. So if you don't have the right planning in place now and your spouse passes away, and even if your spouse passes away and you don't have any planning, there's still some things that you can do in the short term. But let's say you don't do it and now it's 10 years. You're exactly right. You thought, oh, I've got a $14 million net worth, and my spouse had 7 million. Now I have 7 million of an exemption amount. We should be good to go. No, that's not the case. You have to use up your spouse's exemption amount. So with standard estate planning that you'll do, a lot of that encompasses what's called the unlimited marital deduction, right? So an unlimited marital deduction is an IRS rule that says, hey, you can give your spouse an unlimited amount of money, no estate taxes are due, right? Which is great. Even if you're a billionaire, you can give everything to your spouse, no estate taxes come due. But at that point in time, now the spouse has only has their own exemption amount to cover the assets at that point. So with a standard revocable living trust, if you're talking to a competent estate planning attorney, hopefully they're going to put in some provisions there that are going to allow the surviving spouse to use up the first spouse's exemption amount. So that's very key, right? And so you get what you pay for in that context. Hopefully you're not getting I see the signs on the, off ramps from the highway that said to do a trust for $595. And I'm always thinking, well, they're probably not going to get what they really need in a lot of those cases. So go to it, like you said at the beginning of the podcast here, go to a competent estate planning attorney who knows what they're doing, knows how to structure those standard trusts so that, yeah, if you're worth $8 or $9 million, no, you don't have an estate tax exempt or an estate tax that you're looking at, but you need to use up the first spouse's exemption amount if you're the surviving spouse, and you have to have the right trust to do that for you.
So basically, if I understand correctly, husband dies, wife is still alive, obviously. They have 14 million. If the trust is set up right, she can basically disclaim 7 million into basically an irrevocable trust.
Mm-hmm.
And then am I correct on that? And if so, how long does that spouse have to make that disclaimer election?
Yeah, so it's usually 9 months, right? You have to file an estate tax return at that point. And yes, usually if the trust that you've set up has been set up the right way, it allows you to do that very easily. There are some potholes and traps that clients can get into if they don't do that disclaimer the right way. So yeah, at a minimum, having a disclaimer option is very key. If they've done no planning, you can file an estate tax return and claim the first spouse's exemption amount. So you're saying, hey, I've got 7, I want to claim my spouse's $7 million and just keep that in your pocket. That's definitely something that you can do. Hopefully though, you've done your planning ahead of time, so you don't have to do that because that's an expensive process. So, but yes, you're exactly right. Having a minimum of disclaimer as well as other options in those standard plans is key to have that type of protection for your net worth.
Logan, this is really an estate planning mistake type question, but it seems to me when you get into the higher end planning, and I don't do that, but I see this in more basic estate planning with individuals failing to have an appreciation for what is valued as part of their estate. And it seems to me if there's going to be a mistake made against estate taxation, it's this. You get folks, especially that like to live simply. Maybe they don't live, over exotic. They think, well, my house, that's my net worth and what's in my bank account. Meanwhile, they've been building a business for 30 years and they've lived out the income on that. And they've never had an appraise, but guess what? It's probably worth 5, 6, 7 million bucks. Or the life insurance policies that they had that they went and got just to protect themselves. They didn't really think about the fact that, oh yeah, the IRS calls that, your estate and values that. And all of a sudden when you thought your simple life was only worth this, no, it's worth a lot. It's worth a lot less than that. Is that a mistake you see folks make in not doing it, just not putting the right value on some of their assets?
Yeah. It's not the value that you would, just give to your kids. It's what you would sell it for. You're exactly right. If somebody wanted to come in and buy that business, what would be the arm's length transaction cost for that? Yes, that's what's part of your estate. Everything that you own, life insurance, retirement accounts, cryptocurrency, personal property, jewelry, all of that goes into your taxable estate. You're exactly right.
So let's kind of go ahead and pivot now. We've talked about the things you need to think about in terms of basic planning and thinking about what estate tax planning might start to look like and working into that. Let's talk about, though, the high-end estate tax planning, the $20 million net worth person plus, 20 million plus, walks into the door and says, I haven't done anything.
Yeah.
I just sold my business. I didn't think I was this other guy who didn't think it was worth anything. And Google came in and paid me all this money for it. And I've got $30 million in the bank. What are some things that they should start considering? What does that even look like? Take us through that.
Yeah. So as I mentioned before, when we're talking about somebody like that with 20 million and they're looking to grow it over their lifetime, it's a really great idea to do that planning up front. As I mentioned before, most people don't like the idea of giving away control of their assets and the beneficial use and enjoyment of those assets. And that's what a lot of the, whether it be ILITs or you may have heard of the term SLATs, a spousal limited access trust, or other types of IDGITs, irrevocable or defective grantor trust, intentionally defective grantor trust, yes, you're gifting away assets, you're using up that exemption amount now, but you're usually putting somebody else in charge of it, and you don't get the beneficial use of it during your lifetime. So what can be done? Well, the strategy that I like to use in that scenario is called a BEAT it, a beneficiary defective inheritance trust. And it's a lot different from those types of trusts. And I would say those other standard types of estate tax planning trusts in two different ways. One, how it's created, and two, how it's funded. So to help you understand what I mean by this, let me use the concept from a standard trust to help you understand what I mean. So in a standard trust, husband and wife created during their lifetime, what I tell clients is, hey, for the benefit of your kids, instead of leaving those trusts to them outright, or that their percentage to them outright, meaning a check just being written to them, and now that inheritance being at risk in a lawsuit or a divorce or a creditor issue, it would be better for you to set up that trust so that you leave assets to your children in trust. And the kids can be in charge of their own, percent, their inheritance there. They can invest it in real estate or the stock market or their business. But as long as it stays titled in the name of that beneficiary trust, it's protected from lawsuits, divorces, and creditor issues. They can still use it to go to Disneyland and take it out whenever they want to, but now it's no longer at risk in those situations, as well as, and this is a really good part from estate tax planning, when you leave it to them in that manner, if it stays in that beneficiary trust, it's now not part of their taxable estate, right? So if mom and dad are worth 20 million and the kids have all been raised right and have started their businesses and they're worth now 20 million, you're going to leave each of those kids, 10 million each, and now the kid's net worth is 30 million. Well, if you do it the right way, you leave it to them in trust. It's not going to be part of Johnny Jr.'s estate tax, right? Which is nice. So it's not part of their taxable estate. So we're getting back to the BEAT it now, instead of having to wait to get that type of trust when mom and dad die, it would be better for the client, when I'm talking to clients, to get that type of trust now, okay? So the BEAT it, beneficiary defective inheritance trust, is different in how it's created, okay? So Sean, will use you as the example. The podcast just goes bananas, and now people are paying you millions of dollars to advertise on the podcast, and it's worth $20 million. You need to do some estate tax planning. So you come to me and say, hey, I'd like to do that. Great. Let's put together a BEAT it. The BEAT it is not going to be created by you, okay? You're not going to create it. You're not going to gift assets into it. What's going to happen is, if, let's say, mom and dad for you are still alive, it'd be your dad who would be the grantor or creator of the trust. He signs the trust. He's going to fund it with a very small amount of money, usually less than $5,000. That is a gift from dad into the trust. That $5,000 is now outside of dad's taxable estate, and it's outside of your taxable estate as well. Once dad signs it, he has nothing else to do with the trust. He doesn't control it. He's not a beneficiary. No rights with regard to changing anything, nothing. He's done, okay? You are now the trustee and beneficiary of this BEAT it. As the investment trustee, you're now on the hunt for great assets. And it just so happens of a podcast for sale, okay? So what you're going to do is you're going to sell, whether it be the podcast or real estate or whatever it is, you're going to sell your assets to the BEAT it. You're not going to gift them. You're not going to use up your lifetime exemption amount or any of the gift exemption amount that we talked about. You're going to sell the asset to the BEAT it, and you're going to take back a note, okay? Now, the income from the podcast, from the asset, is going to be used to pay off that note. So, you guys are making millions from the podcast. You're using that to go, do whatever, investments, vacations. The normal income from the podcast, from the asset, is going to be used to pay off that note. But now at the end of the day, let's say that note is paid off. You have this asset that's outside of your taxable estate because you didn't gift it away. You sold it. You are in control of it, right? So you're the trustee and you're the beneficiary. If the asset makes money and you guys want to go to Disneyland, what I tell clients is the trust is going to pay directly those costs for you. So yes, you could distribute money to yourself, but now the trust would usually do that. So the asset, whether it be real estate or the podcast, the business, is now in the BEAT it. You're in control of it. it can now grow from 20 million to 50 or 100, and now it's growing outside of your taxable estate, right? So now when you pass away 30 years from now, the $100 million asset can go to the kids and no estate taxes have to be paid. So you maintain control, you maintain beneficial use and enjoyment. You also maintain the same type of tax results as well. So the name of the trust, beneficiary defective inheritance trust. Why would you want it to be a defective trust? Nobody wants a defective trust. That's an IRS term for defective in terms of who pays the taxes. Okay. So normally in most trusts that people create, if I create a trust for myself, me and my wife, and I fund assets into the trust, I'm the taxpayer, right? I pay all the taxes. In this Beat It scenario, we said it was your dad that created the trust for your benefit. Well, he's not going to be the taxpayer. It's going to be defective as to you in terms of who's paying the taxes. So you are, for all intents and purposes, are the taxpayer of the trust itself. So you can contribute, brokerage accounts, real estate. You can contribute S corporations, and all of the same tax consequences still apply because, for all intents and purposes, the Beat It is a grantor trust as to you. You still pay all the same normal income taxes as if you owned it in your personal name. The Beat It does file a separate tax return, but all it says is, hey, this is a grantor trust. Look at my 1040 for the income generated by the assets owned by this trust.
So a couple of questions on that. What about capital gains? So if we sell the podcast, or I sell my share of the podcast to the trust, and let's say my basis in the podcast was, nothing, right? We just started it with, a shoestring budget or whatever. And now it's worth 20 million. And I'm selling it, taking the note back. What am I looking at as far as capital gains?
Great question. So because the Beat It is a grantor trust, the Beat It is essentially you. So at the end of the day, you're selling this asset to yourself, right? So in that context, when you're selling the asset to yourself, at that point in time, there's no capital gains. Okay. So that's another reason why, a Beat It isn't always the ideal solution for everybody, because there's a lot of costs associated with an arm's length transaction, right? You have to get the podcast appraised. You have to do, document the sale of that, of the asset to the Beat It, and those types of things. There's, appraisal costs and everything else involved there, to do it the right way, because we have to have that be an arm's length transaction. You can't say, oh, I've got a $20 million podcast and I'm going to sell it to myself for $5 million, right? That's not a true fair market value transaction. The IRS would undo all of the growth and bring it back into your taxable estate if it is an arm's length. So go ahead.
Now, let's say now, does the Beat It have any limitations in conveying or selling the property, the business after the fact? Let's say Google comes in and says, you know what, you guys really did blow up. Here's $100 million. I want to sell it. Well, now I want to sell it and be out. Any issue selling to a third party like that?
No.
And I guess the basis just carries, your original basis carries to the Beat It. Is that the
right.
idea?
Right. Yeah. So you sell the podcast into the Beat It. You still have the same basis because you're selling it to yourself. There hasn't been a taxable event. Yes, when Google comes along and wants to buy the podcast, because you're the trustee, you can sell any of the assets in the Beat It, no problem. So in terms of running your business, your real estate, your investments, it's the same thing that you were enjoying before. You don't lose any control there. And yes, you can sell to Google, and now you've got $100 million of cash in the Beat It. Now you can invest it however you choose, just as if it wasn't in the Beat It. But now that it's in the Beat It, that growth is still continue to be outside of your taxable estate. Yes, you do have to pay capital gains at that point, of the applicable capital gains. But if it was a piece of real estate that you're selling it, then you avoid those. You're kicking that can down the road.
If Can you swap out the beneficial interest of that trust?
Great question. So normally when my clients come and create a beat it, we usually do a his and her beat it. Okay. And here's the thought process, right? Of husband and wife built a business, built up real estate while they're married. They want to avoid estate taxes. If we just created one beat it and we sold all the assets to that beat it, and you take back the note, and then 5-10 years down the road, something happened, you got divorced. Well, we're not going to divide up the assets any longer. They've been sold. We'd be dividing up the note. And so to make sure that both spouses are protected, we would sell 50% of the assets to one beat it, 50% of the assets to the other beat it, so that they're both, so one beat it is his, one beat it is hers. They both are beneficiaries of that during their lifetime. And then should you pass away, most clients say, I want this to go to my spouse and then my kids. That's, I would say, 90% of kind of the pattern there for most people. Can you change that beneficial interest down the road? A beat it is an irrevocable trust, meaning one of the benefits of a beat it is asset protection when you're selling assets to this third party created irrevocable trust. If you're sued personally, you can say, well, I don't own that business. It's owned by this trust and I'm just the trustee. And so therefore it's not at risk in that type of transaction. So because it's an irrevocable trust, it's much more difficult to change how that trust is administered and distributed. I would say for the most part, no. Are there some ways to potentially tweak it? Yes, but you're getting into some complicated areas of the law. I would say for the most part, no. Some clients, though, will say, okay, I want to create a his and a her beat it. We want to create a kids beat it. We want to create a charity beat it, and that's totally fine if that's what you wanted to do. But yeah, so there's a lot of options there in terms of structuring those assets, especially when you're getting up to the $20+ million range there.
Now, you use the example of Sean's father as the grantor. Is it a necessity that it be a family member, or could it be any unrelated third party?
Yeah, it could be any unrelated third party. If your parents are gone, it could be a sibling. It technically could be a business partner or a friend that you trust. It just can't be you or somebody that the IRS assumes that you control, like a child. Usually, it'd be better if it's not one of your children. So yeah, you have to have a friend who's willing to gift you, $5,000 or less, essentially. And that does have to be a gift. It can't be, hey, let me, give you this and I'll give you. No, it has to be a true gift. There can't be a quid pro quo there.
Well, Logan, we really appreciate having you on. This is high-end cool stuff. I think Sean and I could ask you questions about this for a couple hours. I think we need to do another show and bring you back. Appreciate you being with us. Tell our listeners how they can find and connect with you.
Yeah, so my law firm is the Woodruff Law Firm. The website is WLFAZ.com. Like I said, I do this type of planning, estate tax planning for clients nationwide. I also do asset protection in terms of their, real estate investments and how you own what would be assets that are done through creative finance or whatnot. We can do that type of estate tax planning, asset protection planning nationwide. So love to help.
Awesome. Well, we really, again, appreciate you being on with us, and let's do it again soon.
Great. Love to. Thanks for having me.
All right, Logan, we'll see you next time.
Thanks,
with that, everybody, that is our show. Thanks for joining us. Make sure to join us today at 2 p.m. for The Collective, and next week for our show every Tuesday morning at 10 a.m. We'll see you next time.
Have a good day, everyone.